Okay, let's get going. Good morning, everybody. I hope you're all having a great week. Happy early New Year. Thank you for joining us for our last webinar on our calendar for 2025. And appropriately, we are here with our very good old, not an age, in years of association with NYSERDA, Scott DeLuca. He is an attorney with Ogletree Deacons, and appropriately, he's going to talk about what you as restaurant operators and restaurant folks can expect in 2026. As a reminder, our presentations are recorded. The recordings live in our webinar archive, and as members of the association, you have the ability to access that at any time by logging into our website, NYSER.org. If you have any questions on your login credentials or about anything like that at all, you can email info@NYSER.org and we can help you. And Scott will take questions based on topic as we go through the material. So you can pop those into the Q&A box and I'll be paying attention to those and moderating them as necessary. So Scott, thank you so much. Always good to have you here with us.
Thank you, Sarah. Good morning to you and to everybody joining us today on the webinar. I am Scott DeLuca. I am with Ogletree Deacons. I am a longtime friend of the association. And for those of you who don't know me, I am not only a practicing lawyer for the last 27 years at this point, but I grew up in the restaurant business working for family restaurants for all of my life until about 10 years ago when my parents finally retired. So I come to this knowing what labor and employment law requires of you, but I also know what that means for you and your business, and that can at times be difficult for you. And we try to work with our clients to make sure that they are meeting the legal obligations that they have that we'll be talking about today, but also trying to do what is best for their business so that you can operate in conformity with your legal obligations. As Sarah indicated, we're going to be talking about a number of topics, and on this screen here, I've got an agenda for you. So we're going to be doing a wage and hour update. Of course, with January, the beginning of January comes new wage rates that everybody needs to be thinking about. We're going to talk about those and all the associated rates that go along with that. We're also going to be talking about the One Big Beautiful Bill Act today, and the promise of no tax on tips and no tax on overtime. And at the conclusion of those discussions, I'll have some best practices to share with you. And then we're going to conclude with changes to New York law that are coming in, that have already come in 2025. So we'll have a little refresher on one of them. A couple of other changes that were adopted this year, changes that may come in 26, and some that may come even into the future from there. So we have a number of things to talk about today, and we're going to press forward and get right into them. So turning to the wage and hour update. As many of you know, this falls into two buckets. There is the bucket of what is required in the downstate area, as I'm calling it, which includes all of New York City, Westchester County, and Nassau and Suffolk counties. So the wage rates that you see on your screen right now, those are the rates that would be applicable in those downstate regions. So as of the beginning of the year, your minimum wage rate will remain $17 an hour, meaning that your overtime rate, if you pay an employee minimum wage, will remain $25.50 an hour. If you are employing a food service worker, their tip credit is $5.65, meaning that their minimum cash wage is $11.35. Their overtime rate would be $19.85 for any overtime work, again, if they are paid based on the minimum wage with the regular tip credit. Now, there's a distinction in the hospitality industry wage order between food service workers and service workers. So let's talk about that distinction for a second because it's very important. Food service workers are employees who are primarily engaged in serving food and beverages directly to the guests. They are people who regularly receive tips from guests or patrons or customers for the service that they are provided. Food service workers do not include delivery workers, but in a traditional restaurant setting, they would include wait staff, counter staff personnel who serve food and beverages directly to customers, bartenders, bar backs, bartenders, bar servers, whatever you want to call them, bar backs as well, as I mentioned, um, food runners, bus persons, captains who provide direct service to customers, and a hostess or a host, excuse me, who greets and seats customers, and directly, assists the customers with their service. This is different from, so those are all food service workers. So the middle category on your screen is what is applicable. Before I forget to mention, all of the screens that you're seeing today will be provided to those attending today's webinar and will be available in the NYSRA archive with today's information. So you don't have to worry about scribbling all this down. You'll have these slides after today's program. Now, the distinction between food service workers and service workers, again, it's very important because you see the rates that are on the screen. Service workers are any other employees that customarily receive tips at or above the tip threshold on a weekly basis per hour. So this can be, you don't find a lot of service workers in restaurants. You may in like a coat check, a piano bar, a doorman, things like that, things that are not related to the service of food and drinks, but in a restaurant or hotel or resort. So you see a lot of those types of service employees in resorts and hotels, maybe not as much in restaurants. Then you have everybody else, and that's the non-tipped employees at the top of your screen. So for service workers, they can get a tip credit of $2.85 as long as they achieve the tip threshold of 365 per hour. So what that means is if an employee works 10 hours in a week, they have to make at least $36.50 in tips before the employer can take the tip credit from the minimum wage. If the employee satisfies that threshold, then the employer can take the tip credit and provide a minimum cash wage of $14.15. And then the overtime rate is again on your screen. So those are all of the minimum wage and overtime rates based on the minimum wage for the downstate restaurants. The last important number for downstate restaurants is minimum salary rate. And this applies to all hospitality employers, whether they are large or small, that distinction does not matter anymore. The weekly rate is $1,275. It is looked at on a weekly basis by the Department of Labor during an investigation, but annualize it out is $66,300. Now, remember, for an employee to be exempt and therefore not entitled to overtime, the employee must not only be paid $1,275 a week, but they also must satisfy the duties test. And the duties test is whether they are an exempt administrative or executive employee. There is a professional exemption as well. However, I would caution restaurateurs from trying to rely on that. Even the greatest chefs, I've seen the Department of Labor take the position that they are not exempt, even with the professional training that they may have. Consult with your labor lawyer if you have questions about that. I would also recommend that you consult with your labor lawyer before you go down the road of looking at an exempt employee and paying them a salary and therefore making them not entitled to overtime. There are rampant issues with this. The State Department of Labor has in the past taken the position that no more than one employee on the back of the house and the front of the house can be exempt. Now, that's not published anywhere. That's just their policy interpretation, and that's a position that they have taken during hearings before the Industrial Board of Appeals. But I've heard them take that position, and while I may not agree with it, and I think that it's not really very telling or indicative of how a restaurant or a hospitality employer actually works, it's the position that the Department of Labor takes. So take the minimum salary rates and paying that and making employees exempt from overtime with a huge grain of salt and a lot of caution. Closing out the downstate rates that you need to look at for the coming year. The uniform maintenance pay for high employees, medium and low, which means that for high, the employee is working more than 30 hours a week. Medium is 20 to 30 hours a week, and then low is less than 20. The rates are on your screen. In addition, if you provide meals and take a meal credit, the meal credit rates starting on January 1st of 2026 are on your screen right there. So for food service workers, it's 405. For service workers, it's 475. For all other employees, it's 580. That concludes the downstate rates. So let's turn now to the remainder of the state. So this is going to be everywhere except New York City and Westchester, Nassau, and Suffolk counties. This is the final minimum wage increase that is currently scheduled and slated in accordance with the hospitality industry wage order. So the minimum non-tipped employee rate is $16 an hour, making the overtime rate for that paid employee $24 an hour. For food service workers, and again, we've talked about that, those are individuals that are primarily engaged in the serving of food and beverage to guests or patrons or customers, and they regularly receive tips from the customers for that service. Not including delivery workers and the examples, again, wait staff, counter personnel who serve food and beverages, bus persons, bartenders, bar backs, food runners, captains that provide direct service, and hosts and hostesses that greet guests and provide direct service. Those people would get a tip credit of $5.30. There is no tip threshold for food service workers like there are for service workers. The minimum cash wage for those employees for food service workers would be $10.70 an hour, and the overtime rate is $18.70. For service workers in everywhere outside of the downstate region, the tip credit is $2.70 as long as the employee meets the tip threshold of $3.40 an hour for the whole week. Again, take the number of hours they work, multiply that by the tip threshold number. As long as they make more than that, you the employer, can take the tip credit. The minimum cash wage, if you can take that tip credit, is $13.30. And the overtime rate based on the minimum wage rate is $21.30 for those employers. The minimum salary rate for upstate employers or non-downstate employers as of January 1st is $1,199.10 per week. That averages out on an annualized basis to $62,353.20. Remember, as we discussed previously, in order to be an exempt salaried employee, you not only have to meet the salary basis test, which means that you're paid the amount on your screen right now, but you are also satisfy the duties test of the executive, administrative, or professional exemption categories. Remember the difficulty I mentioned earlier, and that this is an area for caution. Be very wary before you go down that road, before you start making employees exempt and not entitled to overtime. For uniform maintenance pay for high, medium, and low employees as of January 1st, 2026, the rates are on your screen. And then if you provide meals and take a meal credit from your employees and you are in the upstate region, those rates are on your screen. For food service workers, it's $4.10. For service workers, it's $4.40 an hour. And for all, I'm sorry, per meal, not per hour, per meal. And then for all other employees, it's $5.50 an hour for the meal credit that they may be entitled to. That is all that I have for you today on your wage and hour update. With that, we're going to turn to the One Big Beautiful Bill Act. So as many of you may recall, Congress passed the One Big Beautiful Bill Act, and then President Trump signed it into law, I believe on July 4th of this year. One of the things about this legislation is that it seemingly capped a campaign promise of President Trump to provide no tax on tips and no tax on overtime. If only it were that simple, friends. It's not that simple. In fact, this is still a very, very developing area of the law. We at Ogletree Deacons have started a new employment tax practice group focused on issues related to specifically the One Big Beautiful Bill Act and tax issues in general that employers face in their employee relations matters. But we've had a big focus the last almost 6 months now based on the no tax on tips and no tax on overtime. So what is it that the One Big Beautiful Bill Act does? Well, this is going to apply to taxable years 25, 2026, 27, and 28. It will sunset at the end of 2020, excuse me, at the end of 2028, unless Congress passes an extension of it. It's going to affect payroll and wage and hour compliance and employee benefits. There are no income tax withholding changes before next year, but next year there may be some additional changes that are implemented in terms of withholding taxes for income based on overtime and tips, but those changes have not been implemented yet. The IRS is still working on them, so there's nothing that can be done on that front just yet. Um, the amounts that we're talking about for no tax on tips and no tax on overtime remain subject to FICA and other taxes, and certainly state taxes in New York in particular. So it's not an exemption on that front completely. There are separate provisions for overtime and tips, so we need to be careful on what we are going to do on that front. And then the deductions are going to be available for no tax on tips or no tax on overtime based on even if you don't itemize your deductions, because there's going to be a deduction available for that, even if you don't. So turning to no tax on tips, what does that mean? It means that an employee will receive a deduction for qualified tips, which we're going to talk about on the next screen, in customary tipping occupations. We're going to talk about that too. It is capped at $25,000 a year. So if you receive more than $25,000 a year in tips, you can continue to receive it on the first 25, but you're not going to be tax-free on anything after that first $25,000. Also, if you make more than $150,000 as an individual or $300,000 as a married filing jointly a couple, the amount of the cap will reduce for every $1,000 over that cap that you have. So the 150,000 or the 300,000 amounts, the amount that you make over that by 1,000 will reduce the cap of $25,000. The no tax on tips applies to reported cash tips, credit card tips, and tip sharing arrangements. The tips must be reported on the employee's W-2. So it's up to the employee to make sure that they are reporting 100% of their tips to the employer so that they can be recorded in payroll and then properly reported on W-2. If you're going to take the tax deduction as an employee, the employee is going to have a valid Social Security number before they can take this tax deduction. The tips are only exempt from taxes if they are paid voluntarily by customers and are not subject to negotiation. Therefore, it's going to be cash tips in a restaurant, charge tips in a restaurant, tips received through a tip sharing arrangement, debit or gift cards, and other intangible things, such as, for example, casino chips in a casino, hotel, restaurant situation. What is not within that category is banquet tips. If you run a banquet house or you have banquet rooms and you charge a gratuity charge on there, and that is paid by the person holding the event, that is not a voluntary tip, and it is not a qualifying tip for purposes of the no tax on tips provisions of the One Big Beautiful Bill Act. So if you are a banquet server and that is your occupation, you may be, and you occasionally work in a restaurant, the restaurant tips that you receive that are paid voluntarily by the customers, those may be exempt from taxation on those tips. But what is not is going to be any banquet tips or charged tips. So banquet tips are going to be not subject to this. If the restaurant charges, and we've all seen this, a table of six or more, or the restaurant sets a gratuity on a table service, and then charges that amount, and then even if they give 100% of the tips to the server, though that amount is also not a voluntary tip. So it's, oh, and I can't stress this enough, and I've already said it a dozen times, but I'm going to say it one last time. Only voluntary tips qualify. So what is not a qualified tip is a mandatory service charge. an automatic gratuity, amounts that are not reported on a Form W-2. So if you receive tips and you don't report them to your employer, those are not tips that can be deducted from your income tax return. Tips paid for illegal activity or pornography are also not qualified tips. You have to work in a qualified occupation to receive tips. If you work in a restaurant, I don't think that there's going to be any question that you are working in a tip eligible occupation, especially in New York. However, for your information, the no tax on tips law goes further than New York. And what do I mean by that? In New York, it is prohibited by the hospitality industry wage order for back of the house people to receive tips, and they can't participate in a tip share or a tip pool. It's only people who are directly involved in the service to the customers. So chefs and cooks and prep cooks and sous chefs and dishwashers and the people who work in the back of the house are not eligible to be part of a tip pool in New York. And therefore, even though they may be a qualified occupation under the One Big Beautiful Bill Act, they won't be in New York because they're not eligible to receive tips. Sarah, I've seen you pop on my screen. I'm thinking there might be a question.
Yes, and you did talk about this a little bit, but I think just maybe a touch more clarity. Scott,
Sure.
are the tips in a restaurant earned from private events subject to the tax deduction?
As long as they are given voluntarily. So
Right, so it's
whether
not written
it's
into the contract of the event.
if it's not written into the contract of the event. So for example, if you have a banquet house and in the past you have charged a gratuity and you continue to do that, even whether it's a private event or a public event or anything, that is not a voluntary gratuity. That is not subject to the One Big Beautiful Bill Act, and it is not a deductible one. If it is a voluntary tip, that is different, and that is what is deductible. So what we may see is banquet houses may want to change the way they do things, and they may want to remove the automatic gratuity from their contract or from their invoice. They can put a recommended gratuity, and if they pay it, they pay it. If they don't, they don't. Of course, that is a risk. People can decide not that they weren't happy with the service and then pay less. They may pay more. They may do whatever they want to do. So if it's a required charge on an invoice, whether it's a private event or a public event, that what the private or public is not the issue. The issue is whether it's a voluntary gratuity. So if it's charged on the invoice, it's not covered by this act. If it's a voluntary gratuity, it is covered by this act.
Great, thank
Sure. Any other questions from the group? Oh, you've gone away, so I'm guessing no. So I'll continue on, and I'll just note that the categories of employees and occupations that are covered by the One Big Beautiful Bill Act and the no tax on tips is going to be beverage and food service. So again, your wait staff, bar staff, bussers, typical front of the house eligible workers in New York that already receive tips. So I would say if you are participating in a tip pool or a tip share under the New York Hospitality Industry Wage Order, you are most likely covered by the One Big Beautiful Bill Act's no tax on tips provisions, as long as they're voluntary tips. There are a realm of other employees in the world that receive tips. So this no tax on tips legislation goes quite a bit further, and they talk about entertainment and events, and guest services and home services and personal appearance and wellness and recreational and transportation and delivery. So all those other things, to the extent that they receive gratuities, those are also going to be subject to the One Big Beautiful Bill Act. But with regard to restaurants in New York, focus on the front of the house people. The back of the house people should still not be participating in tip shares and tip pools and should not be receiving tips, and they would not be eligible to participate in the One Big Beautiful Bill Act and the tax deduction on tips. Yes, ma'am.
you. So I guess this is a little bit of a reporting. Well, here we go. You're getting there right now. So I'm going to let you go through this, and we'll see if this is still a question for you afterwards.
That's okay. That's okay. I know there's a lot to this, and that's fine. So I'm glad
Yeah.
I'm glad I guessed correctly.
Yes.
So all cash tips are wages unless you earn less than $20 a month. So an employee needs to report the tips that they receive by the 10th day of the following month or more frequently so that they can enable withholding. Now, again, withholding on tips this year will not, in 2025, will not be happening. That's going to be something that changes in 2026 and beyond, as noted under the withholding practices. So for this year, for right now, continue as you have been. The IRS is going to be issuing further guidance on withholding in 2020, well, probably very late this year or very early next year. And there may be changes based on withholdings um, of income taxes under the federal law based on that. But the employer then has to report on the employee's W-2, the qualifying tip amount, and that is now going to appear on box 12 under code TP. And they also have to identify the qualifying occupation code in box 14B. So you should work with your Labor and Employment Council and your accounting service or your W-2 preparation service to make sure that all of the taxes that the employees have reported through the year are reported on the employee's W-2 so that the employee can proceed with the tax deduction on their 2025 taxes, which they will have to do in the first 4 months of 2026. As for withholding, as I noted, employers are to continue withholding income tax on qualifying tips. And in 2026 and beyond, there will be a change on that, and employees will be able to do a new W-4 form to allow for that. So remember, the tips still remain subject to FICA and state income taxes, and New York has not said anything to the contrary on that. So they will continue these tips that may be exempt and deductible from income under federal law will still be income under state law and subject to state income taxes, but not federal income taxes, as long as they comply with all of the other requirements that I've talked about today. Miss Sarah.
Um, so I know you talk about the W-2 form here, but this person is asking, will, let's see, if it is a required gratuity, which is not qualified for this tax deduction, will that have to be shown separately on the form W-2?
That would be shown as just regular wages.
Okay.
It will not be shown in the qualifying tip amount. So qualifying tip amount in box 12 is going to be, excuse me, I'm starting to lose my voice. The qualifying tip amount in box 12 is only going to be voluntarily received tips. So the tips that can be deducted from the employee's wages. If it was a required gratuity, either as a banquet contract or it was a table with six or more and the restaurant charges the gratuity on that group, that would not be a qualifying tip and it should not be in box 12, but it would be reportable as income under box 1 or whatever the normal box is for
Right.
reporting income.
Okay. And then, so this is not for 2025. This will be for 2026, or is it for?
This is for 2025.
Okay. So it
So
is for 2025. It
yes,
does apply for the taxes that your employees will have to do in a couple of months.
yes, correct.
Yes.
So employers need to do this now and should be preparing now with their tax reporting service, their payroll service, whoever they use, so that when you issue the employees their W-2s in next month in January of 2026, as you normally do, there's going to be a new W-2 form and it's going to have box 12 and then it's going to have a code TP. And then in box 14, you got to put what the employee's qualifying occupation code is. So that during the tax year 2025 that we are currently in, employees will be able to deduct their tips from this year's income. So it's 25, 26, 27, and 28, which means that the last time you'll be able to do it will be the taxes that you do in 2029 for 2028, as we all know
Right.
that kooky process.
Um,
Did that make sense, Sarah? I think
yes, it
to
did.
me it did.
Yes.
Okay.
And then how do we verify whether a tip is truly voluntary or mandatory? Is this determined solely by what appears on the invoice? And will we need to formally categorize party pay separately going forward?
So as to the first question, I think that if the employer if it's a banquet event and the employer charges a gratuity on the invoice and that amount is paid, there's no doubt in my mind that that is not a qualifying tip. As the law and the regulations currently stand, that is not a qualifying tip. Um, if the banquet guests pay their entire invoice, and then, as I have seen happen, they go to the manager of the event and they say, here is an extra X amount of money for the staff that served this event. We want you to distribute this amongst the crew in New York. 100% of that has to be distributed directly to the people who have provided the service. So the banquet servers, the banquet bussers, banquet bartenders, anybody in that event. Um, that extra amount, I would argue, is a voluntary tip, as distinguished from the amount that was actually charged. So in my mind, if there is an invoice and it puts a gratuity on there that the customer has to pay, whether it's a banquet invoice or a regular in-restaurant invoice, that is not a voluntary gratuity.
Okay. Um,
There
as
was a
of
second part.
now,
Sorry, there was a second part to that
yeah,
question,
I
and
think
I
you
don't
sort
know
of
that I
answered it.
understood it.
And will we need to formally categorize party pay separately going forward? I think there's a bunch of questions in here that are sort of touching on how are we, what do we as the operators need to put, like, how do we need to keep this separate? How do we need to show this documentation so it's reported correctly? And also all of, let's see, is 2025 prorated at all for that 25K amount? It is the entire 25K
The
amount that can be
entire
deducted.
$25,000. And even though the legislation didn't become law until July 4th, it's retroactive for this stuff all the way to January 1st. So if there are tips that the employee received in January, February, all the way to July 4th, those remain deductible, just like the tips after the bill became law.
Right. So any thoughts or suggestions on how employees might be able to determine what was automatic gratuity or voluntary gratuity for this year?
I think the answer to that is the if there is if you are a restaurant and you do not charge required gratuities, for example, on a party of six or more, and I keep using that as an example, it doesn't matter the number of guests.
Right. It's just a commonplace. Yeah.
Yes, if the restaurant charges the gratuity and puts it on the bill, that is not a voluntary gratuity. Period. Hard stop. If they pay the servers and bussers more, I don't have an answer for you yet because the IRS hasn't given any guidance. Is the first part of it an involuntary gratuity, and then there's a voluntary gratuity on top of it? And this top part would be tax deductible, and the bottom part would not? I can't answer that because the IRS hasn't given us guidance on that yet.
Right.
So I would say for now, you're better off saying if the restaurant charges the gratuity on a bill and that is the amount paid, then that is not a voluntary gratuity and it should not be reported as a qualifying tip in box 12. If it's a recommended gratuity, so if you work in a place and at the bottom of it they list what 18, 20, and 22% are, as I've seen is common practice now, that is not what we're talking about. It's up to the customer to decide how much they're going to provide. The restaurant has provided some guidance on what the percentages are of a typical gratuity, but what they pay is still, you could do a 15% gratuity if that's what you wanted to do. You could, so that would be a voluntary gratuity. But
So now that we have
if
sort
it's
of
on,
sussed out what's a voluntary
sure,
gratuity and what's what's not,
involuntary.
what's involuntary, um, I guess just from a practical standpoint. So I am a server at a restaurant and I have a bunch of tables that are under the threshold of having that autograt added, but I also have some. And at the end of the night, I am reporting in my POS system when I clock out, I'm reporting I made $200 worth of tips. From a practical standpoint, should that employee now have a place where they have to say, I made $100 in autograt tips and $100 in voluntary tips?
I think that that would make a lot of sense.
Okay.
I think that and POS systems are pretty complex nowadays. That's the type of thing that I would expect that a POS system would be able to do. Whether they
Okay.
can, I cannot say.
Of course, obviously.
Whether that's happening already, I cannot say, but it would seem to me that that would be a best practice. Alternatively, you may want to, in your own restaurant, come up with a way for employees to report voluntary gratuities and involuntary gratuities to the employer. I almost
Right.
said voluntarily, but I
Yeah,
stopped
don't do that.
myself.
Don't do
Too
that
many
to them.
voluntaries. So you may want to create a way so that because of this dichotomy, and as a way to encourage employees to report 100% of their tips so that they
Yeah,
get the full deduction that they may be entitled to. You may want to come up with a way to do that in your own system,
right.
whether it's through the POS system or you have a tip log, which of course everybody is required to do under the hospitality industry wage order. I know not everybody does it. It's a pain in the butt. I get it. But maybe the tip log needs to be modified to include a voluntary tip line and an involuntary tip line.
So, um, again, for this year, 2025,
Hmm.
are we thinking that this means that the employer has to go through all of 2025 and separate voluntary and non-voluntary gratuity for accurate reporting?
I would say that they need to do the best job that they can to do so. Yes.
Okay. Okay. Um,
And they should go to and maybe add, I'm sure that employees were not tracking that, but you may
correct,
want to
right.
offer and say, look, if you tracked your tips this year, and you know that some are voluntary and some are involuntary, share that information with us so that we can properly report.
Um, okay. Let's see. If a banquet guest prepays for an event and chooses the level of gratuity they want to pay, does that qualify as a voluntary gratuity?
I don't know the answer. I'm not comfortable answering that question.
Okay.
I'm not sure. It would seem to me that it would, but I haven't read the regulations carefully enough to be able to answer that question. But
Okay.
if the person who is asking that question, if you send me an email, and my email is going to be in the materials that you get, I'll gladly see if I can find an answer for that question because I think that's a good question.
Okay. So you know who you are, that person out there, and you can email me also because I know who
Yeah.
you are. Um,
And I may
let's
know this person. I don't know.
starting from an employee's first paycheck in 2026, will they not be charged federal tax all the way up until they hit the cap of 25,000, or is there a timetable for how this will work?
I don't think that we have an answer for that either yet. It's not that I don't know the answer. I don't think that the IRS has really given us a good answer to the withholding procedures for 2026 and beyond. So that's on the screen that you see right now. That is something that they're still working on. This has been a big work in progress thing. And guidance is still being issued by the IRS on a regular basis. So I would encourage people to hold on tight and see because more information keeps coming out from the IRS. Will make a plug for us at this point. We put out a lot of materials at Ogletree Deacons, and you can sign up for our email blasts for free. If you just go to ogletree.com and look to subscribe to our email blasts. You can also go to our website, again, ogletree.com, and look for the Employee Tax Practice Group. The information that the blog posts and articles that they have published are all on the website and are easily accessible for free to you. And some of those questions may be answered on that website.
And maybe just a quick run through of who in the restaurant is allowed to accept tips. We have a question about outside grill cooks accepting tips.
I would say even an outside grill cook, they're probably cooking and attending to it and then plating it and then giving it to a server to serve it. they're not going to be involved with directly serving the customer. So I would say that they are a non-tipped person. So in New York,
In New York, right?
a tip eligible employee is a food service worker, and we talked about that earlier. And a food service worker is a person that is directly providing food service to a customer, and for that service, they regularly receive a gratuity. Wait staff, bussers, bartenders, bar backs, um, captains and sommeliers, and hosts that are seating customers. All the people on the front of the house, generally speaking, would probably be food service workers. The people in the back of the house, cooks, prep cooks, sous chefs, executive chefs, salad preparation, et cetera, et cetera. And then dishwashers and people even further in the back of the house. Under New York law, those people are not tip eligible. So even if somebody comes to you and says, as a restaurant owner, here is a gratuity for your team. They did an amazing job with our event, and I'd like you to share this with um, the team that provided service, and I want you to include the back of the house. You as a restaurant owner should not do that. And the reason for that is because, say it's 200 bucks. If you split that with people in the back of the house, you've just opened yourself up to an investigation by the Department of Labor, and they could come in and say, you know what? 100% of that was due to tip eligible employees. So the $100 that you gave to the back of the house needs to come back and come out of your pocket, restaurants, because you can't go get it from the people that you gave it to. And you got to give $100 to the servers that provided the service, not just the servers, but the people on the front of the house that provided the service. They are entitled to 100% of the tips, and the people in the back of the house are not.
And then one last question in the box here right now. Any advice for what an employer should tell an employee when they ask, why do I have to claim my tips if they aren't taxed?
Because they are taxable income that is a tax deduction. So the answer to that question is employees always have to report 100% of their tips. And we know that that's not what's happening in the world, but that's the answer
That's
that you
the
should
answer.
always give. And that's the answer that I've been telling employers to give for 27 years and for many years before that too. So they should report 100% of the tips, and then they should report the tips and then take the tax deduction. It's not indexed and benchmarked. If you report $20,000 in tips and you report $50,000 in income, your income is going to be reduced by that $20,000. It's an above the line deduction. So it's not going to be reduced and changed later on, but you have to report all of it to get the deduction. If you don't report it and you take the deduction, you're creating a problem for yourself as an employee.
All
And
right.
I guess the last answer is, without giving legal advice, those employers should say to that employee, that's what the law requires, because it does.
Right. All right. Scott, continue on.
Thank you so much for all those great questions. So let's turn to no tax on overtime for a second, which is similarly nuanced and not easy to understand. So first, the deduction is for everybody. So this is not a hospitality industry limited thing. There's plenty of overtime in the hospitality industry and in restaurants, but it only qualifies for qualified overtime compensation. What does that mean? FLSA overtime only. It's capped at $12,500 per year for an individual or $25,000 a year for a couple. There are phase outs again if you are an individual and you make more than 150K, or if you filed married jointly for 300K. Every $1,000 over those amounts, there's a reduction of $100 from that cap. The overtime still has to be reported on the W-2, and the deduction again requires a valid Social Security number. So, what is qualified overtime? It is only overtime that is received by virtue of the Fair Labor Standards Act. Generally speaking, that would be consistent with the hospitality industry wage order, but I want to be very careful in saying that because it's only FLSA overtime that qualifies. So, and I'm going to give an example that really doesn't apply to New York, but it's an easy way for you to understand this. In California, if you work more than 8 hours in a day, a single day, you are entitled to overtime pay for the time over the 8 hour threshold. That would not be qualifying overtime under this law. In New York, we don't have that. But if New York changed its law and it said that you don't get overtime, you get double pay for overtime, that double pay would not be fully deductible because it's not all FLSA overtime. So, FLSA overtime is when an employee works more than 40 hours in a single work week and they are entitled to time and a half for those hours over 40. So if an employee works for 60 hours in a week, they are entitled to 40 hours at the regular rate of pay and then 20 hours at the overtime premium rate of pay. And what is the deductible amount? That is only the premium. And I don't mean the time and a half, I mean just the half. Here's an example. If you are paid $17 an hour, so you're paid the minimum wage, your overtime rate is, oh God, I got to do public math. What did I say the rate was? Oh goodness. Sorry, hold on a second. I can't do the public math. Sorry, guys. Um, so it's $16 an hour is the minimum wage rate up here. So it's $24 an hour that the employee is entitled to. The amount of the deduction is the $8, not the 16 that they are paid plus the 8. Only the $8 is the amount that the employee can deduct as no tax on overtime. So whatever the overtime premium is, the half, that's the part that is deductible. The first part of it, the payment for the hour of work, is not deductible under the no tax on overtime legislation. Sorry, as we zoom back here. So it's important that the employer is properly calculating the regular rate of pay. If there are any add-ons or adjustments that need to be made to that, that will impact the amount of overtime that the employee is entitled to and will impact the amount of deduction that will happen. Um, what is not qualified overtime is a state with a daily overtime requirement. I mentioned California, that's an easy example. If you are a union house and you have union rules that require the payment of overtime on holidays or after a certain number of hours worked or something else, that would not be qualifying. It's only FLSA overtime. If you are an employer and you have a policy of providing overtime or additional compensation to your employees that's in the guise of overtime, that would also not be qualifying overtime compensation. Again, it's only FLSA overtime. So what remains subject to taxation? If you go over the cap, that would be subject to taxation. FICA still applies, and state taxes are going to apply, certainly in New York. How do we report this? There is no change on the W-2 for this overtime reporting. There is a process being worked on still to provide interim reporting for this year. And in the future, there will be a modification on box 12 for the W-2 in the future, reporting taxable overtime or non-taxable overtime. And you would be able to put that information on the W-2 from there. But for this year, there's not going to be any changes to the W-2 for reporting of no tax on overtime. So what are the best practices that we can offer on the One Big Beautiful Bill Act as we sit here right now? You want to make sure that you track FLSA overtime, not just overtime pay for any non-FLSA purpose. It's got to be that qualifying overtime. Make sure that your employees that are receiving a exempt salary or paid a salary and are deemed exempt, make sure that they're actually exempt. They have to meet the salary basis test and the duties test. You need to make sure that you're tracking voluntary tips separately from mandatory tips or mandatory service charges. And again, be careful in New York about service charges and administrative charges and all that stuff that many of you have heard me talk about before. If you charge an administrative charge and that's money that's kept by the restaurant, that would not go into the voluntary or involuntary tip pool. That's money that the restaurant gets to keep because it's not a gratuity. Make sure that you are only providing tipped occupations being qualified. So that's something to make sure that you're looking at. Ensure that your pay stub and your Form W-2 are reporting in a compliant manner, and that things are changing on that as this is kind of ongoing and being implemented. There's going to be changes to the W-4 form starting next year, so make sure that you bring that new form to your employees when it's available so that they can modify their tax withholding information. And then the last thing, and I've already made a plug for this, I'm going to make a quick plug again. Keep updated on your changes. There are two links here, two articles that were written by attorneys at Ogletree Deakins, my colleagues, on these topics. These articles are meant to be read by the public, and they will be included in the materials that I'm going to circulate subsequent to today's webinar. But if you get the webinar PowerPoint screens, those will be live links. You'll be able to click on them and they will take you to our website. And again, you may want to subscribe to Ogletree Deakins email services so that you are kept informed of developments on no tax on tips and no tax on overtime and other things that are going on in the labor and employment realm. We are coming up on 11:52 in the morning, so I'm going to just mention a couple of things real quick and leave a number of things kind of for the slides. One of the big changes that happened this year, and it happened at the beginning of the year, was the requirement for paid prenatal leave. And this is a topic that a lot of employers properly implemented at the beginning of the year, but many did not. So go back and make sure that you are providing this to your employees. This is a benefit that is only available to pregnant employees during the time that they are pregnant. And during that time, what do you have to do? You have to provide them with up to 20 hours of paid time off to go to prenatal care appointments. It's not an accrued benefit. It's not paid sick leave. It's not anything else. This is a standalone benefit that pregnant employees are entitled to as a matter of law. They don't accrue it. It's not counted like paid sick leave. It is just its own little benefit. It applies to all private sector employers, regardless of the number of employees that you have. And it's for full-time and part-time and exempt and non-exempt employees. Every employee that is pregnant can take advantage of paid prenatal leave. And it's available from the day that they start working for you. It's not an accrued benefit. It's something that they have available right from the get-go. You cannot require an employee to choose between paid prenatal leave or tell them that you have to use the paid leave that we provide you before you get paid prenatal leave. No. If an employee needs to take time off for a prenatal care appointment, they get to use this period hard stop. It can run concurrently with the Family and Medical Leave Act obligations if you are an FMLA employer, as long as it's been designated by you. It allows the employee time off for healthcare services received by the employee during their pregnancy and related to their pregnancy. So physical examinations, medical procedures, monitoring, testing, discussions with healthcare providers about or related to the pregnancy. It's only for pregnant women. It is not for the father or another family member or a caregiver. It's only for the pregnant employee. If an employee is taking paid prenatal leave, you as the employer cannot ask for confidential information about it. You are only entitled to a doctor's note confirming the date and time of the prenatal appointment. I would, as a best practice, make sure that you tell the employee when you ask for a note, if you ask for one, look, I just need a note confirming the date and time of your appointment. I do not need any confidential information, and I'm telling you to make sure that none is included. It should just be a note about a date and time and confirming that you had an appointment on that day. If you have any questions about paid prenatal leave, please make sure that you reach out to me, or again, go to our website. We have lots of information about that. In fact, I did a webinar for Ogletree Deakins at the beginning of the year that remains on our website and is available for view. A couple of other big changes that happened this year. Back in July, Any mandated paid leave for COVID-19 concluded on July 31st. So employees are no longer entitled to any paid COVID leave. If they have COVID and they need to take time off, they'd have to use any paid sick leave benefits that are provided under state law or by you as the employer. Some other changes that happened as part of this year's budget. We paid off a federal unemployment loan from the COVID pandemic, so there won't be a surcharge that's added to employers for that. Starting on October of this year, the maximum weekly unemployment benefit increased from 504 a week to $869 a week, and then there will be future increases for that on the first Monday of October. Striking workers are going to be permitted to collect unemployment benefits after a 2-week waiting period, if that happens. Something that could affect a lot of restaurants. The process for minor employees to get working papers is going to change substantially in May of 2027. So there's still quite a bit of lead up to this time, but as part of the budget, there was changes to the working papers process. It's going to be fully digitized and it's going to be run through the Department of Labor. The employee, the minor, would have to register with the Department of Labor, and then they would provide the information to an employer. That is still a process that is being worked out. But I think the big thing to keep in mind here is that when that happens, we'll have lots of information for you. It'll be digitized, it'll be electronic and digital, and it will not be through the child's schools. So this is something that's being taken out of schools. Couple of other changes. If you don't comply with the weekly pay requirement for manual workers, there were big changes in the penalties that could be seen for that. The Department of Labor got a lot of new enforcement powers in Labor Law Article 6 and Article 7 in terms of making sure that employers are complying with the law. And there were also significant increases in penalties for child labor violations starting in earlier this year. I have listed as part of the program materials a number of things that are still pending. And as you'll see here, a number of them have the status of delivered to the governor. Once something is delivered to the governor, she has 10 days to decide whether to sign it and make it law or veto and send it back. So there's a number of things that were just delivered to the governor. Today's the 10th, I believe. So 2 days ago, on Monday of this week. So she has 10 days to decide whether she's going to sign these or not. I will say that none of these are things that would be hugely problematic for restaurants or unique to restaurants. I think the one on the bottom of your current screen, if you are required to have a workplace first aid kit in your workplace under federal law, you are going to be required to put an opioid antagonist in that first aid kit. So one of those pens that you would use in a nose for a person that's having a reaction to an overdose, or something that you would be able to provide as a nasal or into their leg or whatever the case may be. You would need to have one of those in a first aid kit. But there's nothing else here that is hugely significant for restaurateurs in particular. There was not a huge amount of new restaurant legislation that came across my desk from this year's legislative session. So with that, I'm happy to announce that we did open our permanent Buffalo office at Ogletree Deacons a few weeks ago. So we are now proudly ensconced in Seneca One Tower in downtown Buffalo, and we are open for service. And I'm very proud to be associated with Ogletree Deacons. We are a great labor and employment firm. We have offices all over the world, and I'm proud to see Buffalo listed on that list. But that's where we are located all over. We are significantly committed to our client pledge, which is part of the materials. And that is all my contact information. Again, you don't have to worry about writing it all down. It'll be part of the packet of information that's going to be sent to everybody subsequent to today's webinar. That's all I have for today. And look at that. I hit it right on the nose, right at 12 o'clock. So
That
thank
was
you very
good.
much.
There's one question here that
Sure,
I'll
absolutely.
toss to you before we go, Scott. If there is a reduction of hours, do employees need to receive an unemployment insurance notice if they earned less than $869?
I don't believe so. I believe that the record of employment requirement only has to be provided if employment is terminated. But That being said, if this person sends me an email at scott.deluca@ogletree.com, it's on the screen right now, and it'll be in the materials. I will gladly look into that and answer that question directly to that person. But I'm not 100% certain as I sit here right now.
Great. Okay, it doesn't look like there's anything else, Scott. It's always so nice to take some time with you. We really appreciate it and your expertise and your passion for the industry. It's really a great benefit for all of our members.
It's my pleasure,
Thank
Sarah.
you,
Thank you.
everyone,
Thank you
for
very much.
joining us. Yeah, have a great holiday season.
Thank you. Happy holidays to everyone out there.
Bye bye.